Manslaughter is an act of homicide committed without premeditation, deliberation, or malice. Premeditation is consideration or planning of an act beforehand. Deliberation is to weigh the consequences before acting. And malice is the intention, without justification or excuse, to commit an act that is unlawful. These terms are sometimes referred to as malice aforethought and are what distinguish manslaughter from murder. As manslaughter is not defined by legislation in some countries, common law decisions provide the basis for determining whether an act resulting in death amounts to manslaughter. Common law, also known as case law, is a body of unwritten laws based on legal precedents, established by judges under the jurisdiction of the courts. There are two main types of manslaughter: voluntary and involuntary. The main difference between the two is that voluntary manslaughter requires an intent to kill or cause serious bodily harm, while involuntary manslaughter does not. Within both voluntary and involuntary manslaughter, there are also more specific variations. The type and definition of different manslaughters will depend on the legal jurisdiction of where the crime was committed. Voluntary manslaughter means that the offender did have intent to kill or seriously harm. However, they were acting in the moment, under circumstances that could cause any reasonable person to become emotionally or mentally disturbed. The most common type of voluntary manslaughter occurs when a defendant is provoked into killing. This is sometimes described as a crime of passion. The in-the-moment provocation induces rage, fright, terror, or desperation in the defendant, leading them to act with intent to cause serious bodily harm or to kill. This does not include acting in self-defense in a life-or-death situation. Another example could include the defendant killing a home invader without being placed in a life-or-death situation, when their intent was only to cause serious bodily harm, but they happened to kill the person. Assisted suicide, also known as euthanasia or assisted dying, is the act of committing suicide with the assistance of another person. For example, where a friend, relative, or physician provides a lethal drug to the person to use to take their own life. In some places, including parts of the United States, assisted suicide is punishable as voluntary manslaughter. Involuntary manslaughter is the killing of a human without intent to cause serious bodily harm or to kill. It is distinguished from voluntary manslaughter by the absence of intention to harm. There are two further categories of involuntary manslaughter: constructive manslaughter and criminally negligent manslaughter, both of which involve criminal liability. Constructive manslaughter is also referred to as unlawful act manslaughter. It occurs when someone kills without intent to kill or cause serious bodily harm in the course of committing an unlawful act. To be found guilty of this offence, the defendant must be shown to have committed an unlawful act, and that a reasonable person in the position of the defendant would have known that by their act they were exposing the victim to an appreciable risk of serious injury. For example, a person who fails to stop at a red traffic light while driving a vehicle and hits someone crossing the street could be found guilty of constructive manslaughter. There is no intent to kill or cause serious bodily harm, however, they cause the death of another while committing an unlawful act. The defendant's responsibility for causing a death is constructed from the fault in committing what would have otherwise been a minor criminal act. Involuntary manslaughter may be distinguished from accidental death. A person who is driving carefully and within the laws of the road, but whose car nevertheless hits a child darting out into the street, has not committed manslaughter. That would be accidental death. Criminally negligent manslaughter occurs where death results from serious negligence, or in some jurisdictions, serious recklessness. A high degree of negligence is required to warrant criminal liability. Criminally negligent manslaughter occurs where there is a failure to act when there is a duty to do so, which leads to a death. The existence of the duty is essential because the law does not impose criminal liability for a failure to act unless a specific duty is owed to the victim. It is most common in the case of professionals who are grossly negligent in the course of their employment. An example is when a doctor fails to notice a patient's oxygen supply has disconnected and the patient dies. The doctor owed a duty to their patient once in their care. Another example could be leaving a child locked in a car on a hot day. The parent has a duty to their child, and this duty was not performed. In some jurisdictions, there exists the specific crime of vehicular or intoxication manslaughter. Vehicular manslaughter is when someone unintentionally causes the death of passengers, occupants of other cars, or pedestrians. Intoxication manslaughter is when someone unintentionally causes the death of a person as a result of a voluntary state of intoxication.